no one could have imagined having a working encyclopedia in this house in a form of Judge Roland Sutherland. You are quite lucky to have this kind of a caliber of a judge, the entire deputy judge president coming to preside over your case. You know, you are quite lucky to have a courtroom predator in a form of Professor Billy Gandelfinger to come here and preside over your moot court. There are a lot of many legal practitioners out there who have never appeared before Judge Sutherland, who have never been in the opposite side with Professor Billy Gandelfinger. Over and above that, you are quite blessed to have professor in law, professor, a specialist in labor law, the entire executive deputy dean of this biggest college of law in the entire African continent, being part of the panel to preside over your case. So this is a rich experience which no amount of money will buy. So Moot Court, Mooters 2022-2023, you are quite lucky. And this happens at the time we are celebrating 150 years of the existence of this university. So this is part of the celebration of 150 years of this university shaping futures in the service of humanity. I'm not going to be long because we are running behind the schedule, but I would like to welcome everyone and welcome our presiding officers in this advocacy, training, and all the students who participated, the mooters from other regions who participated in the knockouts. You must be proud of yourself. You did not lose. Actually, by reaching this state, you are the winners. You have won already. It's just that at the end of the day, there must be a winner. But I'm proud of you, all of you, the time you have taken participating in this rigorous process. To the finals today, to the finalists today, I'm saying these judges here, and I repeat, they do not know what you have prepared. They do not know the facts of this case, the research you have done. It's up to you to stand up and convince them. You must persuade them. They are ready to be persuaded by you. So I have a trust, a belief that you are going to do your best. Enjoy it. Enjoy appearing before these great legal minds. Ladies and gentlemen, everyone is welcomed. I hope our online streaming is on, and let's enjoy the day. Thank you very much.
Thank you very much, Advocate Morota. It's always a pleasure to listen to you, and always a treat to see the excitement and the enthusiasm with which you approach and encourage all the mooters and all the attendees in this event here today. So we appreciate you very, very much. Ladies and gentlemen, judges, there will be a slight change in the program. We have asserted that the representative of the management team, Dr. Moroti, isn't in the room this morning due to unforeseen circumstances. So we will pause that now. There will not be anyone speaking on behalf of management as yet. We hope that he will join us in a few minutes, hopefully during the day, failing which. However, we'll move on swiftly with the program in the interest of time, and I will welcome to the podium the chairperson of the Moot Court Committee, who has carried this load burdensome load with such grace and ability and capability, Ms. Obakeng Malapane, just to offer the room, the purpose of the Moot Court, and to acquaint all the attendees with the gist of what we are trying to do as a committee. So please, to the podium, Ms. Mapelane.
Good morning, everybody. I'd like to, first and foremost, welcome our guests. First and foremost, I'd like to appreciate the judges who've made it to this day. As I have said in the past few days, that when a judge or a lawyer takes a day off their schedule, they've taken R1 million out of their schedule. So for them to offer us this much, for them to come here today, it's really an honor. We are honored to have you here. With everything that has happened throughout for you to come here, we really would like to take this opportunity to say we thank you. And to the participants, welcome to the final round of the Moot Court. This has been a long road for you. You have been patient. You have had such determinations. It has been hard. There has been about 100 applicants in each region, and you went through all the rounds. You went through the top 12, you went to the top 3. So today is the day that you have worked hard for. Please take this day seriously. As Advocate Morota have said, not everybody has had an opportunity to present their work before the caliber of judges that we have today. So you haven't disappointed since you arrived. Since you came from all of the regions, from Cape Town, from Durban, from Polokwane, from Johannesburg, you've all been fighting. It has been a battle of words, and you have shown that indeed you are great opponents to each other. As this goes, I'd like to also welcome all the audience that has been with us since the day one of this event. It has been such a tiring day because each day took about 6 to 7 hours of your day. We really appreciate you, and we promise everything that you have taken in today, take it to heart. Take it to heart, because I don't think you are here for with an error. There is a purpose, there's a lot to learn, there is an opportunity for each and every one of you. As for the committee, thank you so much for organizing, for being on my side with everything that I needed. The committee of the Moot Court, it's a committee that was selected by the UNISA Law Clinic. As the UNISA Law Clinic, under the College of Law, we have 4 CAI programs that are meant to assist the needs of our students. We understand that UNISA is an open distance learning institution where learners might find themselves isolated. So these projects are meant for you as law students to come forth so that you can be able to compete with your counterparts that are coming from residential universities. This is meant for you to have the practicality of how to be litigants, not to just know that on paper. This is an opportunity that every LLB student should want to grab. To those who have never been in this program before, this is your time. This is where there will be an application. Students apply for Moot Court applications. They are asked a question or given a scenario. They come in for auditions. The people that you're seeing here came, was auditioned and interviewed and selected from hundreds of applicants. And then they went to the regional competition that is held across South Africa in all of our regions, and there were top 12 and top 3 that was selected from there. And then you come here to argue with your team on behalf of your region. So to all the students, I'm telling you, this is a great opportunity for you to learn, and I hope today you will have a delicacy of intellect. Today there will be a delicacy for you. To those who love to be in an intellectual room, this is what you're going to get. There's going to be an intellectual delicacy today. So to all of you who've been with us, I'd like to say thank you, and we really appreciate you. Looking forward to a great battle today. To all of you, thank you.
Thank you very much, Madam Chair. I can also speak for the Grander Committee. As I say, we really appreciate your leadership. This is not an easy committee to be at the helm of, but you have been very stern, you've been graceful in all your management, and we really appreciate all your efforts. A round of applause, please, for the Madam Chair. Moving swiftly along, ladies and gentlemen, and in the interest of time, I would like to call up to the podium Advocate Saul Magama, who will be engaging the room on the rules of engagement. This is particularly to acquaint all the attendees here today with the formalities, number one, of court and of arguing, and how to approach every single peculiarity of the duties of today. So please, may I welcome with a round of applause Advocate Magama.
Thank you, Program Director. A very good morning to you all. Mine is just to give you a summary of the rules of engagement. The competition was scheduled for 3 days. It started on Wednesday, and today is our final day. So we started with 7 teams from various regions across the country, and we are left with the 2 finalists today. So we are going to have 2 rounds today, unlike the previous day where you had to appear twice. Today you will be appearing once. So please hear me, it's only once. Teams, make it count. Make sure that you give it your all. Each team will be afforded 40 minutes and 10 minutes for rebuttals. And the rebuttal is only for the applicants. Respondents are not doing that. So the issue of 40 minutes, it's up to the teams to ensure how you allocate that. The court registrar will inform both the teams and judges about the time and when the time has lapsed. The judges have a discretion to extend the time and to allow the advocate on the platform to conclude his or her arguments. And then the rules for scoring the competition, as they have indicated, we have 3 justices before us presiding over the case or the proceedings today. And the scores of all the judges in relation to each individual will be added together and divided by the number of judges to reach an aggregate total that will be the final mark for that individual. The aggregate totals of the individual per team, as determined, are added together and divided by the number of the team members to reach the total score for the regional team. I mean for the team appearing. So the team with the highest score will be the winners of the competition. Once the scoring team has tallied the score and determined the winner, then the judges will come back and announce the winner of this competition. Thank you so much, Program Director.
Thank you very much, Advocate Magama, for that brief introduction and outline of the rules of engagement. Moving swiftly along, ladies and gentlemen, I would now like to invite to the podium Advocate Badi, who will be introducing our esteemed judges. Advocate Badi to the podium, please. A round of applause.
Thank you, Program Director. Good morning. Good morning. Thank you. Ka lebitso ke leng Tumetse wa Gapadi, and I'm here to introduce you to the 3 esteemed judges that we have here today. I'll start with Professor Mfari Budeli. She's an admitted attorney. She was admitted as an attorney in 2008. She joined UNISA in 2009 as a senior lecturer in the College of Law. She was appointed as a professor in 2012 and appointed deputy dean from 2020 to date. In 2018, she was appointed as a commissioner of the South African Law Reform Commission to date. Professor Budeli is also one of the founding members of the South African Young Academy of Science. I'll move on to the second judge, Judge Sutherland is the Deputy Judge President of the Gauteng High North, Johannesburg, the most senior judge permanently based at that court. As such, he effectively runs the busiest court in South Africa, situated in the economic hub of the country. The Honorable Justice Sutherland was a prosecutor and a state advocate from 1972 until 1977. He joined the Johannesburg Bar as an advocate in 1977 until 2011. He became a senior counsel in 1995, a judge in 2012, and a deputy judge president in 2021 to date. He extremely effectively runs, and I repeat, the busiest high court in South Africa. Moving along to the third judge, Professor Billy Gardenfinger is a specialist family and criminal defense attorney. He was appointed a professor of law at UNISA in 2011. And aside from lecturing and updating study guides, he is the presenter of the Street Law Community Outreach Program, which has clinics in underprivileged communities. He has for many years annually sat as a judge in the Moot Court. He founded the Black Students Bursary Program at UNISA in 1986. He was appointed to the board of UNISA Foundation in 1998 and was chairperson of the board of UNISA for 10 years. He was a counselor of the Law Society for 6 years. He was chairman of family law of the Law Society for 14 years. He is currently a chairperson of disciplinary of the Legal Practice Council and has been since 2018. He's a trustee of SHOUT, an NPO and an NGO which has built 13 libraries in underprivileged schools throughout South Africa and provided personal protective equipment during the pandemic to hospitals and frontline workers, and promotes education to children in literacy and numeracy programs. He is also a member of the National Executive of the Jewish Board of Deputies. These are your esteemed judges today that will be judging the two teams. Please give us a round of applause.
Thank you very much, Advocate Buddy. Now, before we begin with the business of the day, it would be remiss of me not to welcome to the podium Professor Gardenfinger to offer a message of support to the Mooters, as well as the last words of encouragement, just to revive them and offer them the last giddy up before the business of the day starts. So, to the podium, please, Professor. A round of applause.
Good morning. Advocate Marotta asked me to give a word of encouragement, and when I inquired in what direction I should go, he said, tell the students where you come from. When you, as students, sit and look up at the judges, you make certain assumptions. And what Advocate Marotta was referring to is, where do I come from? So, I'm a German Jew. My parents and grandparents were in the Holocaust, in the concentration camps in Dachau. My father was a country traveler. He's the only man who ever escaped twice from Dachau concentration camp. My mother was a milliner, made hats from home. And when we started off life, We were the only whites living in town, in the area that we lived, in one room with an outside toilet and bathroom. And I'm the only of our family that survived the Holocaust. And prior to that, I'm the only person or child that had a tertiary education. So how did I get this tertiary education? Well, I started my practice at the age of 23, but let's flip back there. The reason I started my practice at the age of 23 was because I'd been working since I'm 12 years old. I worked in the afternoons, on weekends, in bottle stores, in clothing stores. And when I finished my matric, in my matric year, I used to sell pottery in the afternoon. And when I finished my matric, I was quite independent. I achieved a good matric. There was a picture of me in the newspaper. I took it, and I went to the Jewish board and asked them if they would pay for me to go to WITS, to do a BCom LLB, which they gladly endorsed. And I took it to my father, as I said, was a country traveler, and he used to be away at trips anything from 1 week to 6 weeks at a time. And when he came back, I gave him the forms to sign, and my parents didn't speak English very well. My first tongue is German, which is what we spoke at home, and my grandparents who lived with us couldn't speak English. And I gave him the forms, and he said, read to me, what are these forms, what do you want? And I said, well, I want to go to university. And he said, it's interesting, but who's going to pay for this? And I said, but that's what these forms are about. I said, if you sign these forms, then I've obtained a bursary. Anyway, he said, is this charity? Would you have to pay this back? I said, no, it's not charity. I don't have to pay it back. And he called me over, and he gave me a flap in the face. And I said, what was that for? And he said, Gundelfingers don't accept charity, and we're not starting today. If you want to become a lawyer, you must find another way. So I made inquiries, and at the time, my inspiration to become a lawyer was we had no family. Our family was all wiped out in the Holocaust, and a family named Goldstone took us in and befriended us. We lived, subsequently to living in town, we moved to Bertram's, top floor of a very small flat, and our treat was to go to the Goldstones, who lived and had a garden in Orange Grove. And whenever I went there, their son, Richard, was always studying, and he would speak to me, and I was in awe of him. While we were playing, he was studying, and for those of you who don't know, he became an esteemed judge of the Supreme Court of Appeals and the Constitutional Court. So what I'm saying to you is you must follow your dream. As I said, I started my practice at the age of 23 because I was tired of working for bosses. I'd worked for bosses since I was 12. And I literally used to get stuck going to the office some mornings because I had no petrol to put in my car. But I had a dream, and the dream was to get somewhere and uplift myself. And what I'm saying to you, each and every one of you, and I know how hard it is to pay your fees and to get by, and even the effort in getting here today is, for some of you, huge. And what I'm saying to you guys is give everything that you've got. Be passionate about what you're doing. Don't hold back. And look to your career as something that you can achieve and do and put something back. And don't only take out of the profession, put something back, because that will be the most rewarding. Thank you.
Thank you so much, Professor Kandolfenga, for those mighty words of encouragement to our mooters. And I do trust, not only for the finalists, that all of the mooters in the court here today take those words to heart and implement them every single opportunity that they have. Because if you don't have the inspiration to change your own life, nothing will ever change your life. You need to be the catalyst for your own change in a positive way. Again, thank you so much, Professor. Before we now settle in and conduct the formal and important business of the day, may I just note two things. One, for our mooters, please note that on either end, there are your timekeepers. So whilst you are offering the court your arguments, just be aware of the timekeepers. It's the lady and the gentleman as well. So just be aware of the timekeepers so that you can keep track of your argument, as well as be able for the applicants to save some time for your rebuttal. And to the grander audience, may I ask that if you leave the room, please do not make a noise in the foyer, because it actually translates into the room and it disturbs the sound as well. So please be respectful of the proceedings. And with that being said, I think it is now time. It's now time to get on with the most important part of the day. And if there's no other communication from the committee, Madam Chairperson, I now formally declare the court in session.
Good morning, everyone. We'll have the case called now. That's the case between Moot and others against the President of South Africa and others, which comes before us by way of an appeal. Who appears for the appellate?
Your Honourable Justices, greetings. I am Counsel Zororo, and I am appearing with my co-counsel, Counsel Moot and Counsel Boyce.
Thank you. Who appears for the respondent?
May it please the court. I'm Kabelo Matlasi, and I appear with co-counsel Edith Paloy and MADIKIZELA on behalf of the respondents here.
Thank you. Very well, you hear argument now. Please address us.
As the court pleases. Your Honourable Justices, this is an appeal being brought before you from the High Court, wherein our claim was dismissed. This was after the city of Johannesburg had unlawfully evicted the 6 applicants, and the 3rd to 9th respondents had violated the human rights of the 1st to 5th applicants. My duty in this role, Your Honourable in this court, Your Honourable Justices, would be to touch on the issue of direct appeal as well as jurisdiction, but I'll first go into the facts of the case.
Yes, very well. Tell us what we need to know.
Yes, Your Honourable Justice. Your Honourable Justices, there has been a violation of human rights stemming from the perpetuated attacks perpetuated violent attacks, inhumane and cruel treatment, hate speech and deprivation invasion of privacy and appropriation of a dwelling place by the 3rd to 9th respondents. There's been a contravention to the rights of human dignity, equality, and that have been gruesomely infracted by the 7th and 8th respondents through hate speech. The 1st and the 2nd respondents, Your Honorable Justices, have failed in their legal duty to protect the rights of the applicants from the unlawful actions by the 3rd to the 9th respondents. Therefore, we approach this Honorable Court seeking that we be provided relief mandating the 1st and 2nd respondents to act to protect and uphold the rights of the applicants in this matter in compliance to domestic and international law. Your Honorable Justices, there is no dispute of material facts. At the organized and direction of the 6th and 7th respondents, the Operation Restore Order Group, which is the 9th respondents in this case, embarked on violent attacks acting in the name of concerned citizens, which affected residents of Alexandra and Soweto Township, Your Honorable Justices. We argue that South Africa has failed to comply with its international obligations as necessitated by the African Union and UN treaties, as well as international customary law. Your Honorable Justices, permit me, if the court pleases, may I be permitted to move on to the issue of jurisdiction?
Yes, before you do that,
Yes, Your Justice.
you look for different relief from different respondents.
Yes, Your Honorable Justice.
What do you say is your jurisprudential basis for the relief in each of those groupings? You want to take us through that?
Your Honorable Justice, in terms of the 1st, 2nd, and 3rd respondents, the 1st respondent as the president, who is the principal to the 2nd and 3rd respondents, has failed to ensure that they do their duties as necessitated by the Constitution. We therefore seek that he be mandated to take action. In terms of the 2nd respondent, Your Honorable Justices, it is in the High Court facts that there has been no arrest made, even though these violent attacks that we're bringing before this court have been happening for over a decade, Your Honorable Justices. We therefore seek for an order that the court mandates the police to start taking action and stop these utterances from occurring. In terms of the 3rd respondents, Your Honorable Justices, the 3rd respondents, along with the 4th respondents, have evicted vulnerable people from the old Standard Bank house. They are now on the street. We are therefore seeking that they at least provide alternative accommodation. And we are seeking for the court to make a declaration order that they made an unlawful eviction. In terms of the 5th, 6th, 7th, 8th, and 9th respondents, Your Honorable Justices, they are appearing as members of the 9th respondent group, which is ORO, or Operation Restore Order. They have been perpetuating the violent attacks, as Council has mentioned to the court, and they have been breaking into people's homes. They have been attacking people, assaulting and harassing the 1st to the 5th applicants, Your Honorable Justices. We therefore seek that they be held delictually liable for their actions, as the court pleases.
Thank you for that. Will I proceed to deal with the jurisdiction point?
As the court pleases. Your Honorable Justices, we approach this Honorable Court in terms of Rule 19 of the Constitutional Court Rules, which provides for the procedure for direct appeal, wherein any aggrieved litigant who wishes to appeal against any decision by any court regarding a constitutional matter can approach this honorable court, your justices. We contend that it is in the interest of justice that we bypass the Supreme Court of Appeal and approach this court on direct appeal. According to section 167, subsection 6b of the Constitution, the rules of the Constitutional Court must allow a person, when it is in the interest of justice and with leave of this honorable court, to appeal directly to the Constitutional Court from any other court, your honorable justices. We submit that if a matter includes the interpretation, protection, and enforcement of the Constitution, then it is a constitutional matter. As I've mentioned, your honorable justices, we are dealing with issues of the human dignity of the applicants being violated, from them being moved out of a dwelling place and being put on the street, dealing with issues of the right to privacy being infringed, wherein the respondents are barging in to the fifth applicant's home and they're turning her house upside down. We are dealing with issues where the second and third respondents, your honorable justices, have had their show broken into. This is harassment and assault, your honorable justices. We therefore contend that these issues do constitute as constitutional matters, as the rights as enshrined in the Constitution are being violated.
I hear that submission.
Yes, Your Justice.
Perhaps you can deal with this question. On the basis of the interest of justice, do you say that there would be a failure of justice if another court heard this matter rather than we did?
Yes, Your Justice. In terms of the United Democratic Movement versus Speaker of National Assembly, this court stated that coming here we should be able to prove exceptional circumstances, which would include issues of urgency, prospects of success on appeal, and public interest, as well as the savings in time and cost. The honorable justices, when we look at the issue of urgency, it is a very, this is a very sensitive case. As it stands now, the applicants, the 6 applicants, are on the streets and they need immediate relief. Going to a different court, your honorable justice, would not give a final verdict. So that would also be challenging in terms of time and cost. As more time moves, they are more exposed to the dangers of health hazards of being outside in the street, as well as the fact that we are short, your honorable justices, of the resources to be going from one court to another. As it stands, the 6 applicants rather cannot afford a residential place, and therefore they are on the street. We therefore cannot afford the cost of litigation. And according to the EFF case, which is the case of counsel begs leave to refer to the papers, Your Justice.
Yes, please do that.
Can I assist you there? The case is AfriForum and another versus Malema and another.
Thank you, Your Justice. But I think the case I was referring to is the Economic Freedom Fighters and another versus Minister of Justice and Correctional Services and another, which is a 2020 case from this honorable court.
Yes, what is the passage that you want to draw our attention to? What does it say?
Passage 23, Your Honorable Justices, which relates to, may I be permitted to read the passage?
Please do that.
As the court pleases. Delays in the finalization of cases in virtually all our courts bear testimony to the scarcity of judicial resources of this matter that should ordinarily be appealed to the Supreme Court of Appeal are intertwined with the confirmation application that must of necessity come directly to this court. Allowing them to take their ordinary course would mean that the same parties would have to argue the confirmation application here and also approach the Supreme Court of Appeal for the possible invalidation of any offense, part of Section 18, subsection 2B of the Riotous Assembly Act, and for a consideration of the applicant's preferred interpretation of Section 1, subsection 1 of the Trespass Act. Not only would that constitute insensitivity to the crucial need for prudence and frugality in the deployment of court time and other resources, but it would also result in huge expenses to the applicants and a dent to the already overstretched public purse that could have been sensibly avoided by entertaining all these interrelated applications in one forum. Sight should never be lost of the ever-rising cost of litigation in this country, and that many people are acutely under-resourced, where all relevant circumstances are dead amidst avoidable wastage that should be embraced and acted upon. So, Your Honorable Justices, what Council is trying to bring to your attention is the fact that the cost of litigation keeps rising, and the 6 applicants, as they, the first, second, third, fourth, and 6th applicants are foreign nationals who are undocumented, and therefore they may not be able to make as much money as they would like even to sustain themselves. The 6 applicants are out on the street, which means because they cannot afford a place of accommodation. They therefore cannot afford to be going from one court to another, Your Honorable Justice. Therefore, it would not be in the interest of justice for us to move from one court to another.
Yes, thank you. Carry on, move on to your next point.
As the court pleases, Your Honorable Justices, in the sake of time, Your Justices, should the court find that the applicants have jurisdiction, I will now hand over to my co-counsel, Counsel Boyce, who will now deal with who will now address this court on the constitutional obligations of the City of Johannesburg, as well as the obligations of the first and second respondents, Your Justice.
Sorry, before you do so,
Yes,
you're
Your
dealing
Justice.
with jurisdiction, right?
Yes, Your Justice.
Do you think that another court could possibly be the appropriate court? Have you considered that?
No, Your Justice. After considerations, we have realized that no other court would be the appropriate court in this matter, as when we look at the issue of urgency, Your Honorable Justices, the respondents, in referring to the 9 respondents, they are continuing to attack residents of the townships that Soweto townships, as well as the residents of Alexandra. And now, as it stands, there have been reports that such cases are also now occurring in the KwaZulu-Natal, Western Cape, Eastern Cape, and Mpumalanga province. It is very important, Your Justices, that this court makes a final decision so that this case is dealt with as urgently as possible to expeditiously stop such violations from occurring, Your Justice.
Thank you, but have you considered perhaps that the appropriate court might be the Equality Court? And that I can hear your point on urgency, but have you considered that perhaps that basis of an interview pending the hearing of another court.
Your Justices, our case is not only based on the issue of equality, but there are other human rights violations that are also occurring, Your Honorable Justices. The issue of human dignity does not just speak to equality of a person, it speaks to many other aspects. In fact, in the case of SV Makwanyan, Your Honorable Justice, the right to dignity was equated to the right to life, which means that it is a very important right. And as much as the right to equality is important, Your Honorable Justice, it is not the only right that we are arguing before this court.
Thank you.
As the court pleases.
Yes, please proceed, Councillor.
Greetings, Justice. Justices, I intend to deal with the following legal questions.
Sorry, before you go any further, just as a point of order, when each council stands up, they should introduce themselves and hand us a piece of paper with their name on it. So if we could start with the first council so that we can be in a position to assess them according to the score sheet.
As the court pleases, may I take the bench recommendation?
Perhaps I could ask at this stage, while we have the opportunity, if each of you would put your name on the score sheet and send up 3 sheets with your name on, one for each of us.
Can we give you the score sheet? Somebody. So each one was 3 of them. Each has 1 zero, starting from there.
Right, you may hand them up. Reza Pasha. No, keep them until you speak. So only hand them up when you speak. Happiness lines moment. Thank you. Won't you take your seat? We'll call on you. Yes, please proceed.
Thanks, Justices, I intend to deal with the following two legal questions. First being whether the South African government and the Minister of Police have a positive duty to protect the applicants, which is the first to the fifth applicants. The second is whether the City of Johannesburg has a positive duty to provide adequate shelter in a situation where the evicted occupants are alleged to be illegal immigrants. Justices, in setting the tone of my submission, I would like to quote Chancellor P in S versus Makwanyane, paragraph 88. I quote, "It is only if there is a willingness to protect the worst and the weakest amongst us that all of us can be secure that our own rights will be protected." Justices, this is a case wherein the members of the ninth respondent broke down the doors of the first and the second applicants, and they were assaulted. It is a case where the third applicant was harassed and the police did not do anything. This is a case where the members of the ninth respondent broke into the fourth applicant's home and stole his furniture. The fifth applicant and their house broken into and assaulted, and still the police did not react. They did not do anything. Our submission is that the first and the second respondents have failed to have regard to the imperatives of the Bill of Rights. What are those imperatives? We submit that considering Section 8.1 of the Constitution, it provides that the Bill of Rights applies to all law and binds the legislature, the executive, the judiciary, and all organs of state. This section places a positive duty on the state to uphold the rights as highlighted in the Constitution. So from the Constitution, it states clearly it gives them a positive obligation. Having that in mind, Section 10 of the Constitution provides for everyone to be accorded the right to human dignity and to be treated accordingly. Section 205(3) of the Constitution and Section 70 of SAPS Act 68 of 1995 is a more direct reference, where it says that the state, which is the second respondent, is mandated to prevent and combat and investigate crime, to maintain public order, to protect and secure the inhabitants of the republic and their property, and to uphold and enforce the law. Still, the respondents have done nothing, no arrests, no investigations, nothing, whilst the Vigilante group Oro is continuing with their operations. And now there is an oral trend spreading throughout the whole country. In recent history, the first and second respondents have been held to account by this court for having abdicated their obligations. In the case of AK versus Minister of Police, which is a 2022 case, paragraph 74, this court found that the SAPS is liable in circumstances where police officers did not act promptly and effectively despite it being their duty to do so. The second respondent has elected not to act on the actions of the ninth respondent and has not acted against the seventh and the eighth respondents who have incited harm and propagated hatred.
Can I interrupt you? That reference you make to AK versus the Minister of Police,
Yes.
is it addressed in your heads?
Yes, it is.
Can you take it to where that is dealt with?
Admission to
But on page 21, paragraph 30.
yes, Indeed, Justice.
Thank you. Carry on.
As the court pleases. The first and the second respondents have a positive duty to ensure the safety and security of its residents. This we have established, having considered what the Constitution says, having considered what legislation says. Now, perhaps the natural question to ask would be, does this obligation placed on the police also apply to the so-called illegal immigrants? Perhaps that's why the first and the second respondents are not doing anything. It's been 10 years without a solid policy from the first and the second respondents on how to approach the scourge of violent attacks against illegal immigrants. We submit that the respondents don't seem to agree that considering the Constitution and what it says and the obligation that it places on them, they don't seem to believe that they have a positive duty to protect the illegal foreigners. Section 9(1) of the Constitution states that everyone is equal before the law and has the right to equal protection and benefit of the law. Where the Constitution reserves certain rights to particular groups, it has been very clear. If you're going to consider, for example, the civil rights in Section 19, they are reserved for citizens. If we consider Section 22, which is the freedom of trade, that as well is reserved for citizens. However, where the right applies to everyone, the Constitution has been very clear. Most rights in the Constitution apply to everyone who is within the borders of this country. In Prince Lou versus Van der Linde, 1997, paragraph 31, this court stated that human beings are inherently equal in dignity. That includes everyone, citizens or not. In Chapelgate Properties versus Unlawful Occupiers, paragraph 70, the High Court concluded that undocumented foreigners are equally entitled to socio-economic rights contained in the Bill of Rights as citizens would ordinarily be entitled to, insofar as the provision does not specifically provide enjoyment and protection for citizens only. In the Koza case, which is a 2004 case, paragraph 82, this court also emphasized that non-citizens are equally protected by the rights in the Constitution. It is therefore inexcusable that the attacks directed at people perceived to be illegal immigrants or foreigners has been witnessed for over 10 years and the government seems not to want to assist. They do not have as much as a solid policy on how to approach this scourge. The police is placed with a positive duty or positive obligation to protect and secure all inhabitants. We submit, Justices, that the first and second respondents have been negligent in their handling of their duties as far as this case is concerned. It is our submission that the failure of the second respondent caused the applicant's rights to be violated, resulted in the applicant suffering not only patrimonial damage, but also serious psychological and physical damage. We submit, Justices, that the first and the second respondents in this matter should be held liable for damages.
Should we move on to the third respondent? What we're particularly interested in hearing from you is precisely what would be expected of the city of Johannesburg.
As court pleases, Justices. We submit that it is important to highlight that Section 26 of the Constitution seeks to recognize the right to adequate housing as an important basic human right. In safeguarding this right, the Prevention of Illegal Eviction from Unlawful Occupation of Land Act 19 of 1998, which is commonly referred to as the PI Act, gives effect to Section 26(3) of the Constitution. Unlawful occupiers are entitled to be treated with dignity and respect. The third respondent arbitrarily decided to evict residents of the old standard accommodation, or land. The third respondent did not seek to consider any of these circumstances. In fact, they went ahead and evicted residents without an order of the court. In the similar case of City of Johannesburg versus Rand Properties, the 2007 case in the Supreme Court of Appeal, the third respondent obtained an order from the court to evict. And in our case, they have completely disregarded. The two cases, the facts are very similar. In that case, they got an order, and in this case, they've disregarded. In that case, they were directed to offer alternative emergency accommodation. That was what they were told to do in that case. But in our case, they've completely disregarded that. They just evicted and left them in the streets. Again, the question perhaps that must be asked is, has the PI Act or the Constitution through Section 26, does it also cover the so-called illegal immigrants? As I've highlighted through the cases mentioned earlier, the so-called illegal immigrants are entitled to the protections afforded by the Bill of Rights. Therefore, in evicting the so-called undocumented foreigners, the procedural protections and substantive safeguards contained in the PI Act should have been applied as a point of departure. They should have had consultations. They should have considered for how long and in what circumstances they found themselves in that building. They should then also have considered the availability of alternative accommodation. If the respondents would approach the court and submit that they are short in terms of resources, then we submit that they should have at least delayed the eviction of the residents. Because if they don't have the resources, the order of the court and the Constitution gives them an obligation to offer alternative accommodation. And if they can't offer that accommodation, they shouldn't evict in any circumstance.
No, thank you. Do you have a further point to make?
Justices, with respect, these are my submissions. And if it pleases the court, my colleague, Counsel Moot, will now address the court on the freedom of speech and the obligations of the oral group. He will also address the court on the prayers.
Thank you very much.
As a court.
Please proceed. We'll call on you in a moment. Just take a seat. We'll call you in a moment. Yes, please address us.
Honorable Justices, greetings, approach the bench. This is the court. Honorable Justices, I will address the court today on three aspects, which are freedom of expression in relation to the 7th and 8th respondents, obligations of Operation Restore Order, which is in relation to the 9th respondents, and I will then move to the appropriate remedies we seek from this honorable court. If the court grants me leave, I seek to move then to address the court on freedom of expression. From what the predicament is, it is clearly attributable as xenophobia. In the current circumstances, we adopt a holistic definition of what xenophobia is. We submit that xenophobia is the attitude, prejudices, behavior that reject, exclude, and often vilify persons based on perception that they are outsiders, foreigners to the community, society, or the nation itself entirely. This is traceable over the past occurrences in the country, that we can give reference to the predicament which can be highlighted and strike in the articles that were published in the CNN article by David McKenzie in September 8, 2019, wherein he gave an analysis on the surge of xenophobic attacks in South Africa. I will quote, wherein he stated that in an interview of one of the immigrants who was living in South Africa called Mr. Osman, I quote, open quote, "We live among South Africans whenever there are elections, blackouts, or no water, they rob us over and over again," he said. He heard his grandson was killed during the looting in August last year, which was the year before 2018, and his nephew was killed after being robbed just weeks before we spoke to him. He again said,
Is this referenced in your head?
Is
this literature you're referring to referenced in your head?
It is not, it is not.
Thank you. What weight must be attached to it?
Honourable Justice?
What weight must be attached to this information which you're now telling us about, from Mr. McKenzie?
Okay. The manner in which I seek to address this court and point the court to a certain direction, it is that to give a holistic view and context of how this spread of attacks have been happening within the country. That does not begin in this particular year or instance that it is being perpetuated against the applicants, but rather it stems for a past decade. So therefore, we seek to show the court how this has been affecting other immigrants in the past and who are in relation or clearly can be related to how our clients in this particular matter can be related to these instances. So we try to point the court to that particular direction.
It's very well. You can accept that we recognize from the papers which are before us that the problems that are discussed are prevalent throughout the country. That's what you can address us on, is the respective rights and obligations in relation to people in that kind of predicament.
As the court pleases, I was to move on to that particular aspect in my submissions, but if it pleases the court, I will then move to the extracts by the 7th and 8th respondents in this matter, where in the spirit of these attacks, we submit that they are in relation to the high unemployment rates over the years in the ailing South African economy. In reference to the speeches by the 7th and the 8th respondents, it is worth quoting, and for this purpose, he said, which is the 7th respondent, in Costa Susimpi, I quote, "Our borders are porous and our government is doing nothing about that. In fact, it is the very government that has encouraged these bloody foreigners to come here and take away all our jobs that should be enjoyed by South Africans," close quote. In a separate event, in addition, the 8th respondent was quoted in an interview having said, open quote, "The Amangoni nation is a nation of warriors. We cannot allow these cockroaches to disrespect us in our own house." From the extract of the 7th and 8th respondents, their speeches are poisonous utterances filled with hate and incitement of violence, unequivocally directed to all immigrants in the country. These speeches promote and contain hate and amount to hate speech, incitement of violence, under the promotion of Equality and Prevention of Unfair Discrimination Act 4 of 2000, and such is subject to the measures under Section 36 of the Constitution. With specific regards to section, the contentions or the remarks rather of the 7th and 8th respondents, which they use words like foreigners and cockroaches to refer to immigrants. As a starting point from that juncture, it should be considered that the 7th and 8th respondents were in belief that they're exercising their constitutional rights afforded under Section 16, subsection 1 of the Constitution, which provides as follows, that everyone has the right to freedom of expression, which includes freedom of press and other media to receive or impart information or ideas. We therefore are inclined to, and I wish to submit this to the court, that this citation is also not in our papers, but we wish to make reference to the article that was published by Thomas J. Webb, which will be of assistance to the court in reaching its determination.
Sorry.
Is the court please?
If you're making submissions that are not in your papers, what weight must the court attach to your submission?
If it pleases the court, this was just a technical omission made from our side. Rather than now, we seek to make it clearly on record to the court that this would be actually in assistance to the court, persuasive enough that these weights should be considered by this particular court, that in reaching its determination, it would be rather of full assistance. So it is that what we seek from this court, that we actually address.
Yes, we've got your point on that. You want to move on?
Yes, the court, please.
What's your next point?
My next point was to quote a quotation of an article of Thomas J. Webb in Appellate.
We've dealt with Mr. Webb. I want to move on to your next submission.
As the court pleases. Then now it is to be considered that speech is powerful and it has ability to build, promote, and nurture, but it can also denigrate, humiliate, and destroy, in which hate speech is one of the most devastating modes of subverting the dignity and self-worth of human beings. And then it is imperative that hate speech must be prohibited to safeguard the personal integrity of human beings subject to this atrocity extensively to sustain a value-based society which honors human dignity and equality in the spirit of Ubuntu. The words uttered by the 7th and 8th respondents must be appreciated in their true sense and meaning. These words aim to dehumanize and reduce other human beings as subhuman. It is painstakingly relatable to the situation in Rwanda, where Tutsis were reduced to subhuman and dehumanized by virtue of belonging to another tribe, which stirred and led to a genocide. Symbolic languages and gestures.
Let me ask you this question about the word cockroach. Well known in its Rwandan context. Is it appropriate for us in South Africa to simply assume that that word used here would have the same impact as in Rwanda?
As the court pleases. The word, in the narrow sense that the word should be considered, and I beg that this court also employs the same interpretation and acceptance of the definition that may be inclined to this court, that the word cockroach itself has no dignity in itself. Looking at the particular pest it is itself, its characteristics, its place of dwelling, or wherever it is found in a particular environment that is found, no human being can be attributed to such an object. So therefore, symbolic gestures and languages were used in Rwanda, in this instance, to stigmatize, dehumanize, and call them in all sorts of manners that actually degrade their dignity and reduce them to subhumans. So then now, this particular word and use linked to the South African context now has the same effect, to find an extent that persons are no longer going to be considered as, or their human dignity would rather not be considered in this particular instance. And furthermore, it will reduce them to subhumans. So it is our submissions that then now the use of the word is actually offensive to the right to human dignity and also the right to equality, because it tilts the scale of equality in justice and causes an imbalance in society. So it is therefore our submissions that it is a dangerous word to use and should not be used and should be condemned by any from use by any other person in the country. Those are our submissions. It is our it is therefore our submissions that the 7th and 8th respondent have indeed committed hate speech, and their speech is therefore prohibited under Section 16 of the Constitution, subsection 2, subsection 2 of the Constitution, read with section 10, subsection 1 of the promotion to the Equality Act rather. So therefore, if the court pleases, they then move to address the court on the obligations of restore order, which is the 9th respondent in this matter. And therefore, I'll briefly touch on that and move to our prayers.
Let's carry on.
As a court pleases. As a starting point, it is significant that we make descriptions of what Operation Restore Order is. That it is a vigilante group which operates in the guise of clamping down crime in the community. Therefore, under the sections 41, subsection 1 of the Immigration Act, which provides that a peace officer may request for citizenship status with reasonable suspect that such person might be in contravention of the law, wherewith they are not constrained to providing reasons for their request. The definition of a peace officer in this context, in terms of the Immigration Act, is closed. And it's closed to by an extent that it includes magistrates, a justice, police official, correctional officer, class of offense, powered and referred to the notice and issued under the sections 334, subsection 1, and any person who may be deemed as a peace officer. The officials identified in the Immigration Act are only that they may request any person to identify himself as a citizen, resident or foreigner, and that means that only a peace officer or immigration officer can ask someone to produce their identification documents, including your visas and other immigration status related documents. Such steps are those that police officials should undertake to ascertain the identity of a person stipulated under Rule 37 of the Immigration Regulations. Therefore, all members neither qualify under this Act. They are neither police officers, they are neither immigration officers. So therefore, they are acting ultra-vires. They are not within the bounds and protection of the law. So they should be held accountable of their acts. That they continue to harass, to commit and perpetuate violence against the applicants. And it is therefore that they should be held to account, and such accountability must be brought unto them. So it is therefore our submissions in that light that Operation Restore Order is neither an organization that seeks to ensure that crime is clamped down, but it's an organization that is only concentrated on criminal activities. And some of the members are members which are, in respect, members who are actually not mentally capacitated. Second, some of the members that, when they're conducting their raids, they carry binoculars and other dangerous weapons. In a great sense and reasonable sense, any person that seeks to do good may not carry a weapon that will actually cause harm to another person. So it is therefore our submissions that their aims are not as they say. So they should be held accountable insofar as the Immigration Act is concerned, that they are not authorized to search and seek identification of persons, first, and second, that their acts perpetuate violence and infringe on the rights to human dignity and security of persons from all inhuman and cruel treatment. It is therefore our submission. If the court pleases, I will then move to the appropriate remedy which we seek as applicants. Therefore, we beg leave in that regard.
Yes, where do you set out your relief? Is that set out in your heads? Or is it
It is, yes, Honorable Justice. Like this on page 33.
page 39?
Page 33 of the heads.
Yes, right. We have it, paragraph 82.
As a court pleases.
Just bear with us while we have a look at this.
We are to the court.
In paragraph 86, you seek damages on the information before us. on the papers, do we have enough information to contemplate money damages?
This is the court. On that aspect of damages, the co-counsel will deal with that aspect so as this paragraph is concerned.
Yes.
Counsel Boyce will please the court.
It's very well. Would you answer that question?
As a court business. Justices, we took into consideration the extent of the damage as far as the respondents are concerned. We also took into consideration the previous orders that have been given in this court as far as that delictual amount is concerned. And we also took into consideration the extent in terms of the damage as far as their psychological capacity is concerned.
How do you calculate your damages? How did you calculate them?
Well, justices, in calculating the damages, the first thing that we considered, we looked at the previous judgments in which similar cases and how much was rewarded in those cases. And then we also considered the actual, for example, those who have been assaulted, the medical record, and we also took into consideration the medical effects or having to go in medical expenses in the future. So that those are the
current and future.
Indeed, Justice.
What about costs? Nobody's addressed the question of costs.
Justices, I'm sure counsel will address you on the costs. As a copy.
What order do you say you're entitled to?
If this is the court in relation to the cost, it is our submissions that for the purpose of awarding the cost to the successful litigant in this matter, it should be submitted that should the applicants be successful, the first to the third respondents ought to be liable jointly and separately for the applicant's cost in this court, including the cost of two counsels. Even if the applicants are successful in this court, there's no basis for them to be liable. We relay the principle in the BioWatch case that this court held that in general rule for an award of costs in constitutional litigation between a private party and the state is that if the private party is successful, it should have its costs paid by the state, and if there's a successful party, each party should pay its own costs.
Thank you.
Mr. Collins.
Are there any further submissions to be made from the appellant side?
Yes, Honorable Justice, ours to conclude our appropriate relief.
Yes, is there anything you want to add to that?
There isn't.
Thank you.
Mr. Collins.
You may take your seat.
When the
just on a point of order, you also have 1 hour between the three of you.
May it please the court. As previously mentioned, I am Governor McCluskey, and I will be addressing the issues of jurisdiction, direct access, and whether the impugned utterances are constitutionally protected, which are issues 1, 2, and 5 in the set of facts. My co-counsel, Counsel Barloy, will be addressing the obligations of the South African government, as well as the obligations of the city of Johannesburg and the obligations of oral and convenience, which are issues 3, 4, and 6 respectively. My co-counsel, Counsel Adere, will be addressing the admission of Xeno Lives matters as Amicus curia in this matter, and which is issue 7. And then he will conclude by addressing the issue of cost and the relief sought by the respondents. If it pleases the court, I would like to approach the bench too.
Please hand it up.
If it pleases the court,
Before you deal with that, won't each of you retain these forms until you actually speak? You shan't get them mixed. Yes, please proceed.
Counsel will now proceed to address jurisdiction. Counsel for the respondents concede that this court is clothed with the jurisdiction to hear this matter, as it is a constitutional matter that implicates the constitutional rights of the applicants as alleged, and it is a matter that implicates the President's alleged failure to fulfill a constitutional obligation. If it pleases the court, Counsel will now proceed to address direct access. Counsel submits that it is not in the interest of justice to grant the applicants leave for direct appeal to this court. The reasons for this include the following. The SCA has the Supreme Court of Appeal has the capacity to bring urgent final relief in this matter. The applicants could still experience a saving in time and cost through applying the buy-watch principle at the SCA. There is a prejudice to the public interest in granting the leave to appeal directly to this court. And if direct appeal to this court were to be granted, it would burden this court's limited resources. And in addition to this, we'd also like to add another point that there is a dispute of a material fact in this matter. On to the first reason.
Why do you say a dispute of fact would be relevant to whether or not direct access was appropriate?
If a dispute of fact would, as we alleged, has risen, it necessarily means that all evidence will have to be heard to resolve that dispute of a material fact.
Isn't it too late for that? If that wasn't resolved in the first court, then whether it goes on appeal to the Supreme Court of Appeal or to us, we'd be in the same position.
This is where you've got to think on your feet.
If it pleases the court, may the question please be repeated?
Yes. Accept that you're correct in your submission, that there's a dispute of fact. On appeal, what effect can that have on hearing, and more particularly in relation to the topic you're addressing us on now, direct access?
It would not be in the interest of justice, because it would mean that liability will be impugned on parties that actually are not liable for the allegations that are charged against them.
Well, the first court gave a judgment, despite the fact that the oral evidence you say is missing was not adduced. So now what?
Thank you for the question, Justice. The order that it gave was just to dismiss the matter, but it didn't pronounce on the reasons why it dismissed the matter.
Well, let's look closer to your submission. You're saying there ought to be no direct access in this case. Can you use the fact that there is a dispute of fact to bolster that submission? If so, on what grounds?
Counsel submits that because now a dispute of fact has arisen, and now this court is asked to make a ruling on that, if now oral evidence has to be heard, it would prolong the dispute in this court.
Yes, very well. We've heard you on that. Move on.
If it pleases the court, I will proceed to address the SCA's capacity to provide urgent final relief. Counsel submits that the applicants have failed to explain why the SCA will not bring urgent finality to this matter. Rule 10 sub-rule 2 of the SCA rules provide that in urgent matters, an appellant shall file heads of argument together with appeal application or record of appeal, and the respondents file soon thereafter. Further, the SCA Practice Directive dated 28 February 2011 provides that any party that seeks preferent enrollment owing to urgency should communicate this with the registrar by letter for the SCA President's attention. In casu, the respondents admit that it is premature to conclude that there would be a delay in securing a definitive ruling if the matter were brought to the SCA. It is not a foregone conclusion that the SCA will refuse to grant the applicants the definitive final relief that they seek. However, the effect of granting the direct access to this court is that if a party were not to be satisfied with the decision, the party that is aggrieved by the decision would not be able to launch a second appeal. Counsel submits that the applicants fail to set out why urgent relief, final relief, cannot be obtained at the SCA, and on this ground, leave for direct appeal should be dismissed. The second reason that we'd like to address is that they could still experience a saving in time and cost if the matter were referred to the SCA. Counsel submits that if the applicants were to vindicate their constitutional rights at the SCA, they would still be relying on the violence principle at the SCA. If the SCA were to be satisfied that the applicants successfully relied on the violence principle, the implication is that the respondents would be marked with paying the applicants' costs. Counsel submits that the applicants are in effect preempting the outcome of the SCA, the dispute at the SCA, in order to justify a direct appeal at this court. Such an abuse of court process is not in the interest of justice. Accordingly, counsel submits that the applicants fail to provide sufficient reasons why it would not save on time and costs in the SCA, and that direct appeal should be refused on this basis. I now move on to the third reason, which is the prejudice to the public interest. Counsel submits that it is not in the public interest to grant direct appeal in this matter. In Radio Pretoria versus Chairperson of the Independent Communications Authority of South Africa and another, this court held that there may indeed be instances where it is in the interest of justice for this court to decide a constitutional matter for the benefit of the broader public or to achieve legal certainty or other public purpose. Counsel submits that this is one of those instances in that granting direct appeal would be a missed opportunity for this court to benefit from the jurisprudence that would come from the SCA. The jurisprudence would benefit the broader public, considering that this is a matter that implicates the economic and social impact of illegal immigrants in the Republic. Counsel submits that this court should bear in mind that many South Africans are unable to participate meaningfully in public participation processes. And the reasons for this is, on the one hand, many South Africans fear that airing their frustrations would lead to secondary victimization by some illegal immigrants. Some of these illegal immigrants have demonstrated criminal propensity, and this is prevalent in society at the moment, as evidenced by stripping of national infrastructure, hijacking of buildings, the establishment of illegal electricity and water supply connections, the sale of illicit goods and substances, the abducting of women and children into human trafficking rings, and so on. On the other hand, many South Africans are unable to air their frustrations and contribute towards developing the public policy through public participation processes and fora, or owing to the challenges associated with their social and economic conditions. These include, for instance, the lack of a financial means to travel to public participation hearings on immigration issues, as well as the lack of financial means to employ legal service providers to explain proposed policies and bills, etc. Thus, the respondents submit that it would not be in the public interest to grant the applicants direct access to this court on these cases. The fourth reason that we'd like to draw to the court's attention is that granting direct access to the applicants would burden this court's limited resources. Council submits that it would not be in the interest of justice to grant that direct appeal and use this court's limited resources to resolve a dispute that the SCA is in as good a position to resolve. Ever since the 17th Constitutional Amendment of 2012 that expanded the scope of this court's jurisdiction under Section 167, subsection 3 of the Constitution, this court has been inundated with matters to resolve. Yet, under Section 167, subsection 4 of the Constitution, this court is closed with exclusive jurisdiction to hear matters that involve, for instance, disputes between organs of state in the national and provincial sphere, and disputes that involve the alleged failure of the president to fulfill a constitutional obligation. Considering that Section 172, subsection 2 of the Constitution provides that this court shares concurrent jurisdiction with the SCA, and that this court is also mandated under Section 172, subsection 4 of the Constitution to confirm orders of constitutional invalidity by the SCA, Council submits that it is manifestly unreasonable to burden this court with having to decide this direct appeal. And on this basis, again, direct appeal should be denied. So to summarize Council's submissions, it is not in the interest of justice to grant direct appeal to the applicants because it would burden, the SCA has the capacity to provide urgent relief, or even temporary relief. The saving in time and costs at the SCA will still be experienced if they rely on the buy-watch principle. It would prejudice the public interest to grant direct appeal, and that it would burden this court's limited resources. If it pleases the court, Council will now proceed to address whether the impugned utterances are constitutionally protected.
Thank you.
Council submits that the impugned utterances by Mr. Mani and Nkosi Sisimbi are constitutionally protected. And to provide a bit of context, in Dikoko versus Mukata, this court described freedom of expression as the lifeblood of an open and democratic society cherished by our Constitution. Section 16 of the Constitution affords individuals the right to, among other things, receive or impart information or ideas, but obligates such individuals not to incite imminent violence, nor to advocate for hatred, nor to incite the causing of harm. Section 10 of the Equality Act, read with Section 1 of the Equality Act, gives effect to this by prohibiting people from communicating words that are reasonably understood to be intended to harm or incite harm or promote or propagate hatred against anyone based on, among other things, their ethnic or social origin. To provide a little bit of context when it comes to now how to interpret this, authors Dario Mello, Glenn Penfold, and Anthony Stein explain that the rationale for the protection of freedom of speech, freedom of expression, includes 5 factors, which are the search for truth, the proper functioning of a democracy, the self-fulfillment and audience autonomy, the encouraging of tolerance through a diversity of opinion in a pluralist society like ours, and providing an avenue for undesirable views to be aired through unsuppressed expressions rather than through violent conduct. In Hotz and Another versus University of Cape Town, the court held that courts should not hastily conclude that language that conveys hostility or has racial or ethnic overtones is to be characterized as hate speech. In Sanif and Others versus Economic Freedom Fighters and Another, the court cautioned against readily declaring offensive or controversial statements as constituting hate speech. The court also held that even if language qualifies as hate speech, if it fails to incite harm or to reasonably understood as inciting harm, then no liability arises. This then raises the question, what does reasonable mean? And in South African Human Rights versus Kumalo, the court held that the test for hate speech was whether a reasonable person could conclude, and not inevitably should conclude, that the words being the author had a clear intention to bring about the prohibited consequences. In Kasu, counsel submits that the reasonable person has not objectively understood the words to incite violence or imminent violence, nor to harm nor cause harm. Further, that the imputed utterances are political rhetoric, and that this is part of the parlance of revolutionary politics in South Africa. Firstly, it is common cause that Nkosi Sisimbi and Mr. Mani are members of the Azanian Economic Liberators Party. Counsel submits, and we can find this in the set of facts at paragraph 8 and 11. Counsel submits that the reasonable person understands that revolutionary politics often uses political rhetoric that is militant, that agitates, that offends, that shocks, that disturbs a sector of the population, and in this case it is their audience, their supporters, to proactively improve their living conditions by, for instance, participating in the township economy or in democracy in general. This is why, for example, Mr. Mani is affectionately known as El Comandante, despite not being of Latin American descent, despite not being a military official or having history as in the military, and despite not having a history of being involved in guerrilla warfare. Secondly, counsel submits that as members of the South Africa's second largest political party, AEL members understand that they should be careful not to jeopardize their prospects of becoming the governing party. Hence, its members and supporters sprang into action to assist Oro. And this can also be seen in the set of facts at paragraph 11 and paragraph 9. Counsel implores this court not to hastily import nor conclude illegality in how the supporters of AEL, including Nkosi Sisimbi, assisted Oro. And this is in line with the principle of Hotz, how the court reasoned in Hotz and Another. Fighting the illegal immigrant problem could be achieved by, for example, reporting illegal immigrants to the relevant authorities, reporting the sale of illicit goods to the relevant authorities because of the impact on local township economies, and reporting the individuals who are providing accommodation to illegal immigrants for non-humanitarian purposes to the immigration authorities. Thirdly, it is common cause that the alleged unconstitutional violations of the applicant's rights preceded the utterances being made. And this can be seen, for instance, at paragraphs 7, 6, and 5 of the set of facts. The assailants were acting with criminal propensity and to further their own interests. Further, some of the assailants were learners of a primary school for mentally challenged individuals. These are manifestly not reasonable people. To summarize, Council submits that the impugned utterances are constitutionally protected in that the reasonable person understands that revolutionary politics often uses political rhetoric that is offensive as part of the parlance of revolutionary politics. Again, that this court should maintain the objective standard and not import nor conclude illegality regarding the impugned utterances and how the utterances were understood by the relevant people in the set of facts. And thirdly, the manifestly unconstitutional conduct preceded the utterances that were made and were not committed by reasonable people. Accordingly, Council submits that the impugned utterances are constitutionally protected and that the applicants fail to prove that they are prohibited and that the relief sought by the applicants should be dismissed. If it pleases the court, I will now hand over to my co-counsel, Edith Baloy, who will address the court further on our submissions.
Thank you very much.
I am Counsel Edith Baloy.
And the Queen's.
Don't we have an usher?
Yeah. In a court, you normally have an usher. So we'll appoint this lady to be the usher.
Take a seat, we'll call on you in a moment. Please address us.
This is the court. I am Counsel Edith Baloy, and I'll be dealing with issue number 3 and 4, the obligation of the President and the Minister of Police, and the obligation of the City of Johannesburg. Since the court is well versed with the facts of the case, the counsel of the respondent would like to proceed with the merits and arguments of the case. My justices, we submit to this honorable court that the respondent have fulfilled their governmental obligation to respect, protect, and enforce the human dignity and security to the applicants. The respondent submits that the executive powers of the President are provided for by Section 85 of the Constitution, which stipulates that the President and his cabinet implement national legislation and perform the executive functions provided for in the Constitution or national legislation. On policing, we submit to this honorable court, my justices, that in Section 205 of the Constitution, read with Section 85 and 91 of the Constitution, provides that the Minister of Police and the President are merely mandated to structure the South African police services to function in all spheres of the government. We submit to this honorable court that the South African Police Services Act and the Criminal Procedure Act have both been enacted as a legislative means to give effect to Section 205 and 206 of the Constitution. In Glenister versus the President of the Republic of South Africa, this court held that under Section 7, subsection 2, there are a number of ways in which the state can fulfill its obligation to protect the rights in the Bill of Rights. The Constitution leaves the choice of means to the state, how this obligation is fulfilled, and the rate at which it must be fulfilled must necessarily depend upon the nature of the right involved, the availability of the government resources. In conclusion, the President and the Minister of Police submit that they have fulfilled their governmental obligation to the applicants through legislative and other means. They further submit that it is unfortunate that their fulfillment of their governmental duties towards the applicants are not felt. However, that is due to the limited available resources and extreme demands on such resources. If the court pleases, if there's any, can I be any further of assistance to the court?
Well, let's have a look at what you've just said to us. Did we understand correctly that the President and the Minister say that they've, through their power to create legislation, addressed as best they can the need to protect South Africans, but that they are unable to do any more to implement those laws? Is that the proposition?
Thank you for the question, my Justice. We submit that the mere fact that the President's best effort may not have produced the best results desired by the applicants in this case does not mean that the President has failed to uphold, defend, and respect the Constitution as the supreme law of the country.
So who must we hold accountable for non-implementation?
My Justice, thank you for the question. We submit that in case of in-law Society of South Africa and others versus the President of the Republic, this court held that the President should not unnecessarily be constrained in the exercise of constitutional powers, and that a court should be slow to impose obligations upon government which will inhibit its ability to implement policy effectively. As a young democracy, my Justices, we submit that facing immense challenges of transformation, we cannot deny the importance of the need to ensure the availability of the executives to act efficiently.
Thank you. Thank you for that.
If it pleases the court. We submit, my Justices, in the city of Johannesburg versus changing, the court considered whether the city was obliged to provide temporary emergency shelter to undocumented foreign nationals that have a legal basis to be in South Africa but were unlawfully occupying property. In this case, my Justices, the court held that if the living conditions of the unlawful occupiers poses a risk to their life, health that necessitates eviction as soon as possible, the city should review the statuses of the unlawful occupiers after eviction to avoid unnecessarily delaying the eviction processes. By doing so, the rights of undocumented foreigners who are unlawfully occupying are balanced with the rights of the property owners and the interests of the state. If it pleases the court,
Yes, no, carry on. Carry on.
To summarize council's submissions, my Justices, the city submits that occupiers should not be granted restoration of the old Standard Bank building, and instead the city should be directed to provide temporary emergency accommodation to the occupiers only after the occupiers have verified their status. If it pleases the court, I may now refer to my co-counsel who will be concluding with the cost relief and amicus curiae.
Thank you very much. Yes, Mr. Kaderi, please address us.
May it please the court, I'm Counsel MADIKIZELA. I'll be making submissions on the admissions of Amicus curia, cost and relief. The admissions of xenolife matters is certainly not a matter of interest. We submit that it will play no role in assisting the court to arrive at an just and equitable decision. They argue that they have in possession crucial evidence that would assist this court. We submit that an evidence, especially tendered by an amicus curia, needs to pass this test. I'd like to shed some light to the court on Rule 31 of this constitutional court, which is not mentioned on the set of facts. Rule 31, Subrule 1, paragraph B. States that material submitted to the court needs to be official, scientific, statistical in nature, capable of being verified easily. We submit that the evidence tendered does not meet the requirements set above because the verification is questionable. And no one knows whether this evidence has been tampered with to push its own narrative. They rely on the evidence only. They rely on this evidence they submitted. And we are very much aware in the set of facts on paragraph 8 on the set of facts that we have a quote by Deborah Mani uttering words. And everybody is well, my learned colleagues and I and my learned colleagues are very much well furnished with those set of facts. In that event, indeed the evidence is unacceptable. Nonetheless, and captures series of events that are common cause, and that is the evidence is indeed in the papers. Justices, therefore, generally, xenolife matters will therefore be repeating the submissions that we are making. And I further note that my fellow colleagues have not noted the admission of the xenolife matters. So I plead with the court that this will be the only admissions that will be admitted by the court. In regards to remedies, I'd like to refer the court to page 33 of the set of facts, rather the head of arguments. They are well stated there. In alignment with the course.
Just bear with us while we get there. Page 13.
Page 33. The start page, sorry, my lord, it starts at page 33, rather justices. Page 33, page 30, page 32, page 33.
Paragraph what? 10.
Yes, paragraph 10.1.
You have it? Carry on.
Moving on to the post, in accordance to the by-watch principle, if litigant is not substantially successful, the court should order the parties to pay its own cost. In order of saying that, they failed to approach the SCA and let the SCA do its job in accordingly and which is stated by the Constitutional Court. If the bench has no questions, counsel begs to say. Those are the conclusions.
Thank you very much for your submission.
As the court pleases.
I will now move on to the reply from the appellant, who will address us on that.
As the court pleases, Honorable Justices, I will deal with the aspect of freedom of expression. My co-counsel will deal with the rest of the issues.
Please carry on.
As the court pleases. Could I then refer, Honorable Justices, in your papers to the case Koilani versus South African Human Rights Commission and others, which was held in this court in 2019, specifically at paragraph 23.
Yes, continue.
In which this court held that hate speech is a detestation, hate speech as an extreme detestation and vilification which risks provoking discriminating activities against a group which seeks to violate the rights of another person or group based on group identity. Hate speech does not serve to stifle ideology, belief, or views in a democratic and open, broad-minded society like ours. Disturbing or even shocking views are tolerated as long as they do not infringe the rights of persons or groups of persons. Therefore, it is worth noting that statements by Operation Restore Order leaders and leaders of the AEL, 7th and 8th respondents in this matter, constitute what we call, and what this case says, that they are extreme detestations. So therefore, it provokes this discriminating act as referred to this particular act of the case.
Yeah, we've got that point. That's the point you made in the argument. What is the proposition advanced by the respondents that you want to rebut?
Insofar as a court basis, insofar that is concerned, it is noteworthy that the intention in this particular instance should not be material. That is therefore that we submit that the interpretation of the statements and expressions must be considered in their appropriate meaning. And therefore it is noteworthy that what was uttered cannot be undone, worse in the circumstances that such speech is divisive and has led to harm in society. We have seen that after the utterances of the 7th and 8th respondents, the upsurges continued, and more people were actually affected in various areas of the country. So we cannot say that these utterances were of good nature. So therefore, it is our submissions that inasmuch as Section 16, subsection 1 of the Constitution affords the right to freedom of expression, the thrust of Section 16, subsection 2, paragraph C, is to disallow the practices and tendencies and the laws of our ugly past and just and unjust past as any space of finding expression or application. Therefore, reference is further made to the case of the Economic Freedom Fighters versus Minister of Justice and Correctional Service, where this court held that when one incites others under the guise of freedom of expression to cause race or gender-based harm, the inciter may not look at Section 16.1 for exoneration. This is what we see in this instance, that the 7th and 8th respondents have performed such actions. And therefore, it is our submissions that they have acted within the bounds which are prohibited under these quoted sections of the Act and the Constitution. If it pleases the court, that is the aspect that I have made submissions on, and applicants seek to give co-counsel, my co-counsel, Becky Boyce, to further make submissions on. If it pleases the court.
Thank you very much.
We counsel what?
As court pleases. Justices.
Are you what?
No, Justice.
They did change. Yes, Mr. Royce, you may address us? No, we're pretty good. Yes, what do you want to address in the respondent's argument?
Yes, as the court pleases justices, I'd like to draw your attention to paragraph 25 of our heads, which defines what the responsibility of the first and the second respondents is concerned.
Let's go to paragraph 25 of the heads. What page is it on?
Page 13 of our heads.
Yes, we've got it.
Justices, in that paragraph, we outline that section 205 gives the mandate for the police to combat and investigate crime, and specifically section 17, that's paragraph 26, it gives the National Commission the obligation to establish and maintain a national public order policing unit to maintain and restore the public order. Our submission, justices, is that the responsibility of the operations of the South African police does not stop at the lower level, at the level of the constables. It goes as high, the responsibility and the obligation is placed on the commissioner, and it goes as high as the Minister of Police. And the first respondent, as the head of the state, he is also the head of the executive. He is also responsible as far as the operational issues are concerned. As such, justices, it is our submission that indeed this is the issue be brought to this court and to account for their omission as far as their obligations are concerned, as far as what is outlined in the Constitution and the Act, which is the South African Police Act. Justices, our submission with regards to jurisdiction, we submit that sight should not be lost, that as we speak there is continued violations of human rights as outlined in the Constitution. And having to go through to the Supreme Court of Appeal gives or exposes us to the risk of having to come and appeal again in this court, which further delays the relief that the applicants seek. It is therefore our submission that the agency, as far as the stopping of those violations of the human rights, is important, and it is incumbent on this court to stop such violations from continuing. If there be no other questions, justices, these are my submissions.
Thank you. You may take your seat.
As a court.
We're going to adjourn to consider, and we'll adjourn until 12:15, and then we'll deliver judgment. Okay.
All right, that's the first business. All right.
Thank you, ladies and gentlemen, for your indulgence during this session. Thank you also for obliging with the House rules in terms of the noise and the movement around the room. As the judges deliberate the case and come back with a judgment, I would like us just to pause, maybe grab a bathroom break if we need, and then at 12:15, we can entertain the judges again when the judgment is ready to be delivered. Thank you.
Actually, they're looking good here. Yes. I'm just going to ask Council on this side. Sorry, Council on the mic. Sorry, Council on the mic. You need to move backwards. Thanks. Thank you. Yeah, be the member. Thanks. Okay, that's good. That's good. It's okay. Sorry, okay, that's not wrong, just fine. Thanks.
Try to grab it, but it's just
Thank you.
Are you good?
No, good.
Okay. Timmy,
What are the clauses? The winning And then these
So sorry, may I just steal this moment? As you know, I'm not the MC before Abuya or SK. I am Tembisile Maho, and I'd just really like to plead with you to please follow us on all our social media platforms at UNISA Law Clinic. I'd also just like to ask the students, are there any that are already following us on social media? Yay! Yay! Nice to see you guys. So you saw on social media and then you came through. Thank you so much for coming. We truly appreciate. Will you be applying to be the next Mooter? Yes. All right, thank you so much. Remember, we've got all our 4K plans. Please do apply. We want your participation. We need your participation. And also, if you want to be on the social medias today, just come to me and then we can do a short video of your idea. Okay, I see those hands there on everything, right? Did you see the head of the law clinic? Yes. Yeah, so he's making it all possible for you guys, and he really, really wants you guys to leave this institution with as much certificates as you can. So please apply, and thank you so much. Bye. Thank you. Outside. No. Oh, you want to ask something?
May I have your attention? May I have the room's attention? So there has been a slight amendment to the program as we know it. So the judges have requested, not even requested, indulged themselves on an extension of the deliberation up until 1 o'clock, after which we will convene back here and they will offer constructive criticism, the delivery of the judgment, as well as the prize giving. Such that after all of that proceeding, we then enjoy lunch and then the competition's officially over. Just to save everybody's time and be respectful of everyone in the room. Thank you.
So I guess it was
Seated.
Thank you very much, ladies and gentlemen, for indulging us that time and for the judges to deliberate and come to a decision on our case today. So before we proceed on to the more ceremonious parts of our program, I would like to invite Judge or Professor Gandalfinger to Judge Sutherland to offer the constructive criticism on both our Moot court teams, just to encourage you and to offer you some insight on how the mechanisms of law works in a real setting and to draw parallels with your experience here today. Thank you, Judge.
Well, first of all, can I congratulate both teams on getting here to the final. And may I say that you should be very satisfied with yourselves in regard to the way you have presented the case. For effectively individuals who have had no real time in court, time in the trenches, I can see that all of you have applied your mind quite carefully to the way in which you have presented your cases. One of the biggest and most important aspects of preparing and presenting an argument is that it's got to have structure. You need to remember that as the consumers of your advocacy, the judges have to be able to understand what you're saying, follow your line of thought, and know that as you go through your argument, you're dealing with each subtopic, as the case may be, as you go along. And all of you, to a greater or less extent, have expressed in the way you conducted your case an appreciation of that need. One of the things that you do need to watch out for, and it's something that happens even in court, particularly with younger practitioners, you have to make a very careful distinction between what point you are addressing and whether it's a point of law or you're dealing with the factual narrative. This often shows itself when a question is posed, say a question of law, and the answer which is given is actually a factual narrative, which would reflect that you didn't quite grasp the point that was being asked. It's very important to be able to read the judge's question in the context in which it's put, so you can deal with the question. Narrative issues and legal issues need to be separated clearly in your mind when you do that. One of the things that you need to remember is that your heads of argument are a tool for you to use as much as for the judges to use. So when you write them, don't think of them as a ritual that you have to go through in order to satisfy a rule of court or a rule of practice. It's an actual thing that you can use. And one of the things that I noticed in the presentations today is that very little use was made of your heads of argument. When you are arguing in an appeal court, such as this matter, you can always assume that the judges have read your heads beforehand. So we're never looking for you to read your heads back to us. When you now address us on the highlights, but you want to go into detail on something, that's a good place to use the heads, because then you can say, I now want to deal with point X. We've addressed this at page 33, and I want to refer to you to a passage I've cited from the affidavit with evidence, or you can say, there are two leading cases on this proposition, which we've referenced at this point. And if you go to quote case, you can then take the judge to the portion where you put your quotation in, and you can read it together. That's a very good way of ensuring that your argument gets digested. The other thing that I want to raise is your personal presence as a human being on your feet. It's always important to try and maintain eye contact with the judge. Try to avoid reading off the desk. The temptation we all do get into when we're a bit nervous, but you need to keep your head up and your chest out, and you need to make some kind of connection with the bench. For those of you who are very tall, the trick is to put your briefcase on the desk in front of you so your papers aren't too far away. So part of oral advocacy is that dynamic interaction with the judges who you listen to. And another thing you need to bear in mind when you're appearing before a number of judges, as you will do in appeals, is not to ignore any of them. Because you never know who's going to write the judgment. It's not always the judge in the middle. And you want to catch the eye of who is going to write the judgment. He's usually the one who's scribbling the most. And that's the chap you need to persuade to accept what you want to say. The rest can fall in with him or her. So those in broad strokes are things I want to say. What I was impressed with, and by all means, it, I suppose, is a logical outcome of having come through the whole competitive system, is that all the champions are here today, and you've acquitted yourself very, very well. I hope you're proud of yourself. I hope your friends are envious of you. And thank you very much for the effort you put into making this Moot a really rewarding experience for everyone.
We will now deliver the judgment.
The matter before this court calls on every inhabitant of this country to confront the very challenging circumstances in which we find ourselves. On one hand, we face the ever-growing challenge of crime, unemployment and limited resources in South Africa, and on the other hand, the question of how we should relate with foreign nationals in our country. A tension which has no easy point of balance. Judge Sachs said in the Union of Refugee Women and Others versus Director of Private Security, xenophobia is strong in South Africa. It strikes at the heart of our Bill of Rights. Special care accordingly needs to be taken to prevent it from even unconsciously tainting the manner in which laws are interpreted and applied. If refugees are treated as intrinsically untrustworthy, the capacity to perform honestly and reliably being placed presumptively in doubt, then xenophobia is a given and our constitutional values are undermined. Constitutional response to xenophobia need not, of course, involve exaggerated xenophilia, just as refugees should not be protected from irrational privilege, so they should not be able to claim irrational privilege. The law must be applied in a manner that is fair, objective, and appropriately focused, and in keeping with the letter and spirit of our international and national legal obligations. It is without a doubt that a balance has to be struck which ensures that the principles upon which our constitutional democracy is built are not undermined by the derogation of the rule of law. This application was brought by Mr. and Mrs. Ahmed, Mr. Nzalo, Mr. Bani, Mr. Kanu, each of which were harassed in various ways by members of the ORO, including through bodily harm and destruction of property, because they were foreign nationals. The sixth applicant, various occupiers of the old Standard Bank house, were forcibly removed from a hijacked building in downtown Johannesburg by a security company, the Red Dragons, who were commissioned by the city of Johannesburg. The justification for these forced removals is that the occupants were living in squalid conditions, in buildings which, among others, have no ablution facilities, water and electricity, except that which has been illegally connected. The first set of respondents include the President of South Africa, the Minister of Police, and the City of Johannesburg. They are cited in their capacity as organs of state responsible for protecting and upholding the rights of applicants. In addition, the Red Dragons are cited for their role in the forced removals of the occupiers of their old Standard Bank house. The second set of respondents are Nonhlanhla Boboza, Rawling Siabata, Tibogo Mani, Nkosi Supempe Igoni, and the organizers of the ORO in South Africa. Mr. Boboza and Mr. Siabata are the driving force behind the ORO, which is a vigilante group in Alexandra, which seeks to eradicate criminality in and around Alex, making it safe and hospitable. They seek to assist law enforcement in getting rid of drugs, drug dealers and criminal elements. Further, they seek to promote economic freedom by ensuring that what they call the Kasi economy benefits indigenous South Africans. Finally, they seek to reverse the problems associated with illegal immigration. ORO led meetings mobilizing community members to form armed vigilante groups, which would then conduct night patrols of raids directed at known drug dens and foreigners, operating various businesses in Alice. The raids resulted in the harassment and the applicants as described above. Additionally, although Alex was the epicenter of the attacks, the violence spread to 4 other provinces. Mr. Mani and Nkosi Supimpi Ngoni are cited for making possibly inciting and inflammatory remarks which encouraged their followers to join ORO in their vigilantism. It is their remarks which resulted in the activities of ORO spreading to other towns and informal settlements. Thus, the Minister of Justice is being held responsible for not placing anyone under investigation and not arresting Mr. Mani or the Nkosi for their instigatory remarks. The Police Commissioner asserts that the remarks are mere political rhetoric. Zeno Lives Matter is a non-profit organisation which is not registered in South Africa because its conveners are all undocumented immigrants from Zimbabwe, Eritrea, Ethiopia, Pakistan and Iraq. Its members have been collecting evidence and as such they seek to be admitted as Amicus curia. This move is opposed by both the Nkosi and Mr. Mani. The matter before the court raises a number of important issues. Jurisdiction, direct access to the constitutional court, the duty of the government and of the Minister of Police to protect the right to human dignity and security of the persons affected, and the obligation of the Valaji Group ORO not to violate those rights. The duty of the City of Johannesburg to protect socio-economic rights as far as it relates to the occupants of the old Standard Bank House. The right to freedom. And lastly, the admission of Zeno Lives Matter as an amicus curia before this court. The applicants have brought an application to the Gauteng High Court seeking an order in their favour wherein they argue that human rights have been violated and the government failed to protect them against unlawful attacks. Further, they argue that South Africa has failed to comply with its international obligation in terms of the African Union and the United Nations treaties and international customary law. The applicants seek to vindicate their constitutional rights to human dignity and security. The contention has been raised about whether the High Court has jurisdiction to hear this matter, as it involves constitutional issues. The argument has been made that the matter should be heard by the Constitutional Court and direct access is therefore being sought. While the Constitutional Court is the apex court on all constitutional issues, it benefits greatly from the views espoused in the lower courts. More so, the findings of the magistrate and high courts, because they have the benefit of hearing and interrogating evidence more robustly. The decision on whether direct access to the Constitutional Court should be granted is dependent on a number of considerations, some of which have been laid out in the decision in Member of the Executive Council for Development, Planning and Local Government, Gauteng, versus the Democratic Party and others. It was held there, in deciding what is in the interest of justice, each case has to be considered in the light of its own facts. The factor will always be that the direct appeals deny to this court the advantage of having before the judgments of the SCA on the matters in issue. Where there are both constitutional issues and other issues in the appeal, it will seldom be in the interest of justice that the appeal be brought directly to this court. But where only issues on appeal are constitutional issues, the position is different. Relevant factors to be considered in such cases will, on the one hand, be the importance of the constitutional issues, the saving in time and costs that might result if a direct appeal is allowed, the urgency, if any, in having a final determination of the matters in issue, and the prospects of success, on the other hand, the disadvantages for the management of the court's role, and the ultimate decision of the case in the SCA is bypassed. The issues raised in this matter need to be interrogated closely, with the the reading of evidence and examination and cross-examination of witnesses. The saving of time and costs are not the only factors that should be considered when deciding what would be in the interest of justice. It is therefore our decision that it is appropriate that the Equality Court should exercise jurisdiction over this matter. The admission of Amicus Curia is governed by the provisions of Rule 9, which is underpinned by the principles that the submissions of an amicus should be relevant to the proceedings and raise new contentions which may be useful to the court. The role of an amicus is to provide helpful submissions to the court. It must not repeat arguments made, but must raise new contentions based on evidence already before the court. In other words, ordinarily, an amicus should not try to introduce new contentions based on fresh evidence. Lives Matter have approached this court seeking admission as an amicus because they believed that their intimate knowledge of the issue and vast collection of evidence would be of assistance to the court. The opposition to this by the 7th and 8th respondents was that their participation would waste the court's time and resources. We are disinclined to agree with that proposition. There are two ways for a party to get admitted as an amicus curia. The first is through written consent of all the parties to the proceedings. The second is for an applicant for admission to bring an application to be an amicus and address it to the court, which will then exercise its discretion. In the latter case, the court will weigh the value of the submission to determine whether they will give the court assistance would not otherwise enjoy. While ordinarily it would be appropriate for amicus to introduce new contentions based on fresh evidence, the court may exercise its discretion to allow that participation. Lives Matter are not seeking to raise new issues before the court. The contentions they make and the evidence they have collected are directly relevant to the matter at hand. It would be beneficial to the court to have access to best evidence directly from the source. At the heart of this matter is the constitutional rights the applicants allege to have been violated by the respondents in various ways. These include the right to equality, derived from Section 9, human dignity, Section 10, and the right to freedom and security in Section 12 of our Constitution. The respondents have in turn raised in defence of their actions the right to freedom of expression derived from Section 16 of the Constitution. It is therefore incumbent on us to briefly unpack these rights. The Constitution provides in Section 2 that it is the Supreme Court of the Republic, and any law or conduct which is inconsistent with it is invalid. This places an obligation on everyone in the Republic to act in accordance with the rights and responsibilities in the Constitution. Section 9 provides this. Everyone is equal before the law and has the right to equal protection and benefit of the law. In Section 10, that everyone has the inherent dignity and the right to have their dignity respected and protected. And lastly, Section 12C of the Constitution provides that everyone has the right to freedom and security of the person, which includes the right to be free from all forms of violence, from either public or private sources. Each of these rights is available to everyone under the authority of the Constitution of the Republic of South Africa, which means that everyone who is within our borders must enjoy these rights, irrespective of their status or their nationality. The applicants have regrettably found themselves as victims of harassment and violence simply because they are foreigners in South Africa. The attackers have not provided any evidence that can prove any of the allegations they make of criminal conduct on the part of their victims as a justification for their abhorrent actions. Even if they could do so, they have not the authority to take the law into their own hands. To condone vigilantism would contribute to a slide towards anarchy and a fundamental undermining of the Constitution that serves as a social compact which regulates our society and lays down principled rules. essentially similar in all civilized democratic systems of government. So how those who place themselves outside the law are to be dealt with. The duty to detect, investigate, and stop crime lies only with the South African police service. They are the only legitimate source of crime fighting. What is more, members of the ORO and other vigilantes cannot use misguided claims of patriotism as a justification of their actions. The only way a society can flourish is through the adherence to the rules of law, and anything short would lead to anarchy. Even the police, who are tasked with fighting crime, are constrained by the standing orders and the provisions of the South African Police Services Act, but they are not a law unto themselves. There is no space for vigilantism in a constitutional democracy such as ours, no matter how frustrated we may be. It is determined, therefore, that the rights of the applicants as laid out above have been unjustifiably violated by the members of the ORO, and as such, Mr. Barbosa, Mr. Siabata, and the organisers of ORO South Africa must be held accountable for their roles as leaders of the group. The Minister of Police is called upon to investigate the violations and act accordingly. The second set of respondents, Mr. Mani and Nkosi Gordon, have been accused of inciting violence through their public utterances. Mr. Mani is quoted as saying this: "Our borders are porous, and the government is doing nothing about it. In fact, it is the very government that has encouraged these bloody foreigners to come here and take away all the jobs that should be enjoyed by South Africans. Comrade, we cannot allow that. We must push back. We must fight this recolonization of our economy. Otherwise, the South African child will die without tasting economic freedom. We are not afraid to die for our economic freedom. We are ready to take a bullet for that. We are not ready," incoherent part of the quote, "bullets to those who jump our borders." Similarly, the Nkosi Ngoni is quoted as saying this: "Have you ever seen a Utlami or Magashu running a shop in India? Have you ever seen a Uzikalala selling drugs to young children in Zimbabwe, in Pakistan? We should not allow ourselves to be abused in our own house. We should not follow that. The Amagoni nation is a nation of warriors. We cannot allow these cockroaches to disrespect us in our own house. Where are the warriors of old, the sons of our great kings of yesterday? Why are they allowing our land to fall into an abyss?" The right to freedom of expression in our country is contained in Section 16 of the Constitution. What it says is this: everyone has the right to freedom of expression, which includes the freedom of the press and other media, freedom to receive or impart information or ideas, freedom of artistic creativity, academic freedom, and freedom of scientific research. But there is a proviso. These rights do not extend to propaganda of war, incitement of imminent violence, or advocacy of hatred that is based on race, ethnicity, gender, or religion, and that constitutes incitement to cause harm. Mr. Mani and Nkosi Ngoni are accused of making statements which incite imminent violence or advocate hatred based on ethnicity. And as such, these statements would not be protected under the right to freedom of expression, as they constitute hate speech. Their defense is that these utterances are nothing more than political rhetoric, and as such are protected. The Promotion of Equality and Prevention of Unfair Discrimination Act, the Equality Act, is instructive in the determination of this issue. Section 10 of the Equality Act prohibits hate speech. It provides this: no person may publish, propagate, advocate, or communicate words based on one or more of the prohibited grounds against any person that could reasonably be construed to demonstrate a clear intention to be hurtful, be harmful or to incite harm, promote or propagate hatred. Further, this section provides, without prejudice to any remedies of a civil nature under this Act, the Court may, in accordance with Section 21(2)(n), and where appropriate, refer any case dealing with the publication, application, propagation, or communication of hate speech as contemplated in subsection 1 to the Director of Public Prosecutions having jurisdiction for the institution of criminal proceedings in terms of the common law or relevant legislation. Section 10 must be read with the definition of the prohibited grounds in Section 1 of the Act. Those grounds include these: race, gender, sex, pregnancy, marital status, ethnic or social origin, color, sexual orientation, age, disability, religion, conscience, belief, culture, language, birth, and HIV/AIDS status. Any other ground where discrimination based on that other ground, 1, causes or perpetuates systemic disadvantage, 2, undermines human dignity, or 3, adversely affects the equal enjoyment of a person's rights and freedoms in a serious manner that is comparable to discrimination on the grounds set out in paragraph A. In order to determine whether speech is hate speech, it is instructive to engage with the meanings of the words. The court in Afriforum versus Malema held this: in the absence of an innuendo, the test is whether the reasonable person of ordinary intelligence is taken to understand the words alleged to be defamatory in their natural and ordinary meaning. In determining whether this is the position, the court must take account not only of what the words expressly say, but also what they imply. The context within which these words have been used cannot be ignored, and reference is made to decisions in Argus Printing and Publishing against Essendon, and Siamela and others versus Independent Newspaper. The meaning behind these words used by Mr. Mani and Nkosi do not need one to perform mental gymnastics to interpret. The contempt for non-South Africans in South Africa is clear and undeniable. Nkosi Ngoni's use of the word cockroach to describe foreigners cannot help but draw one back to the murderous rhetoric adopted during the Rwandan genocide in 1994. These utterances were made in public and as such must be treated as a publication to the nation. The intention of the person who utters the words are irrelevant. What is important is the determination of the meaning of the words from the perspective of the reasonable listener or to a portion of society. The facts in this matter reveal that the words uttered were received by members of the public and unfortunately acted upon. This has led to a proliferation of violence in other provinces. The meaning of the words are therefore clear and unambiguous. It is therefore determined by us that this speech is indeed hate speech and as such is not protected by the right to freedom of expression. Mr. Mani and Nkosi Ngoni may thus be found liable for hate speech. Hate speech is prohibited because at a personal level, as experienced by the individuals of the targeted group, it is a direct invasion of their dignity and an infringement of their rights of association. As regards the duty of the government in relation to international relations and obligations, it was remarked in State versus Giller by Mr. Justice de Wet, violent attacks against foreigners have become a real and common reality in South Africa. These senseless and mostly unsolicited xenophobic incidents are difficult to reconcile with a post-apartheid reality. The role of the law in curbing xenophobia is found in the Constitution, which states, everyone has the right to freedom and security of person. Our country, under international law, is obliged to respect the basic human rights of any foreigner who enters our country. This means that every foreigner is entitled to the rights that are enshrined in the Bill of Rights as provided for in the Constitution, save for those which are restricted to South African citizens. To do this would not only be in line with South Africa's obligations to international instruments, it would also be consistent with the obligation under Section 7.2 of our Constitution to respect, protect, promote and fulfill the rights in the Bill of Rights. These protections are all enshrined in the Promotion of Equality and Prevention of Unfair Discrimination Act No. 4 of 2000, the Refugees Act No. 130 of 1998, and the Protection of Harassment Act 17 of 2011, and lastly the Immigration Act 13 of 2002. It is accordingly declared that the Government of South Africa does have a duty to uphold its duties under national and international law. It is for these reasons that we make the following report. 1. Zeno Lives Matter is admitted as Amicus curia. 2. This matter is referred to the Equality Court for hearing. 3. The respondents are interdicted and restrained from publicly uttering any words which incite violence towards foreigners, either directly or indirectly. 4. This order is effective only on the first date upon which the matter may be heard in the Equality Court once all the parties have filed their submissions. Lastly, 5. The costs will be reserved for a decision by the Equality
A copy of the judgment can be obtained after the hearing. There's a copy for the applicants and the respondents.
Thank you very much to Judge Sutherland and the justices on the bench for that very informative and very far-reaching judgment, which I'm sure is invaluable not only for today but for other matters which are likely to be seen before this court. Now, with that formality aside, ladies and gentlemen, I am excited to come to the more joyous portion of the program where we will be offering the prizes and congratulating each and every mooter in this room today, both for participating in the various rounds of the knockouts as well as here in the final. So to assist me in this very important job, may I welcome Ms. Zindle Katani, the Senior Attorney at the Law Clinic. A round of applause. Shall we put this aside? Yeah, for the pictures. Pardon us, ladies and gentlemen. So the order of granting the prize medals will be ascending. So it will follow that order throughout up until the ultimate prize. So for the bronze medals, I would like to congratulate Team 7, Cape Town, and Team 6, Johannesburg. May I have Team 7 and Team 6, please? Cape Town and Johannesburg, please come to the podium. A round of applause. Round of applause. Thank you very much. So ladies and gentlemen, that was the bronze medals for Team 7 Cape Town, as well as Team 6 Johannesburg. I am proud and very excited to grant the silver medals to 3 teams. Team 1, Durban. Team 4, East London. Team 5, Ekurhuleni. Worked very hard. Live TV, ladies and gentlemen, live TV. Run-of-the-mill live TV. Thank you, ladies and gentlemen. For the gold medals, I am proud and very excited to present Team 2 and Team 3. Thank you very much, ladies and gentlemen. That was Team 2 and Team 3, Polokwane and Pretoria, for the gold medals for making it into the finals. Another round of applause, please. And now, for the awarding of the best memorials, may I have Professor Budeli Namakonde join me on the podium, please. The moment of truth. Ladies and gentlemen, it is my honor to congratulate and to award a tie for best memorials to Team 2 and Team 3. The team leader, please join us for a picture. We'll have a joint picture and then a picture with either team leader. The trophy can float between the teams, 6 months, 6 months. But the bragging rights are forever. How you share it is up to you. Congratulations, a round of applause. And now, to announce and to award the best oralist, may I have Professor Gandalfinger join me on the podium? Now, I would just like the room to understand exactly the inner workings of deciding who the best oralist is. Imagine addressing actual professors and judges of esteemed courts, people with long resumes. It takes courage and it takes grit to hold on to yourself, be convicted and understand your argument and stay the nerves and whatever might try to get you. So in deciding this, it was, I think Professor Gandalfinger will decide much earned, much earned. But the runner-up first for the best oralist, ladies and gentlemen, Kabelo Mashas. A picture. A substantial round of applause, ladies and gentlemen, please. Thank you for that. Now, the owner of this much-coveted trophy, the best oralist of the 2022 UNISA Inter-Regional Moot Court Competition, ladies and gentlemen, I am proud to present this award to Big Ngosi Boys. Thank you, Professor. Ladies and gentlemen, for the biggest award of them all. Now, let me just contextualize this. The granting of the application by the applicants does not necessarily mean that they are the winners of today. The respondents also could have won. The judgment pertains particularly to the teams and the arguments. However, for the winner, for the handing of the judgment, the handing of the award and the trophy for the winner of the 2022 UNISA Inter-Regional Moot Court Competition, may I ask Judge Sutherland to join me on the stage. Ladies and gentlemen, I think this one deserves a drum roll. And the winner of the 2022 UNISA Inter-Regional Moot Court Competition, Team 3, the applicants! Thank you. Could we have the coach for the winning team on the podium, please, for pictures? A round of applause, please. Oh. May I have Advocate Murota to join us on the podium, please? Sure. much. Thank you so much. Thank you. All of the sport, improvising. Thank you, Prof. Thank you, Prof. I don't know how we did it. My whole year we've been thinking of it. Thank you, Prof. Thank you. Ladies and gentlemen, thank you. Thank you, ladies and gentlemen, thank you. Thank you, ladies and gentlemen, thank you, thank you. Thank you, ladies and gentlemen. Thank you, thank you, thank you. Thank you. Oh, guys. Thank you, thank you, thank you, thank you. Thank you, ladies and gentlemen. Thank you. Thank you, thank you, thank you. Advocates. Advocates. Woo. It's because of the singer. Advocates. Thank you, ladies and gentlemen. Thank you. We have one more. We have one more item on our agenda. Thank you, ladies and gentlemen.
Halala, clinic halala. Colleagues, only 1 minute so that we close the program officially.
Please.
And then thereafter we can do the celebrations outside. Thank you very much.
And it actually concerns our esteemed judges. We would just like to offer the trainer and the Madam Chair of the Moot Court Committee an opportunity to provide you with a word of thanks and a token of appreciation. Please, thank you.
Halala Pitori halala. Halala UNISA Law Clinic halala. Halala the College of Law halala. Thank you so much, ladies and gentlemen. Really, this has been a beautiful event and it couldn't be auspicious without any of you. Your presence here, you might not be aware, but it has planted a seed. The reasons we have these students over here, all of us here are contributing in putting a seed. These children today, they saw what hard work brings. They were honored by the highest esteemed judges. All of us today are witnessing something that is huge. I'd like to thank each and every person who made their way to come here. We really appreciate you. I'd like to also appreciate the ULSA, UNISA Law Students Association, for organizing all of these students to make sure that our children are aware of what education can do for them. We really appreciate you. I'd also like to take this opportunity to thank all of the coaches that have coached this finalists. This program has been running since last year, February. They've been coaching them religiously without getting tired. They've taken time out of their busy schedule. They are lecturers, they are advocates, but they have taken time to invest into what we are seeing today. I'd like to also thank the staff of UNISA, my colleagues. Oh wow, I don't know what I am without you. You guys kept me sane in this time. You have come through. You have come through every time that I needed you. And as for my boss, Advocate Morota, say I thank you so much for this opportunity. I didn't think I can do this, but when you believed in me, even though that I felt that I'm just a candidate, but yet you gave me such a platform. It's a seed that you're also building. So I'd like to thank you so much, and may God bless you, and wishing you all the best with your future endeavors. We thank you so much. And in absentia, I'd also like to thank the Deanery of the College of Law for every time making sure that we are able to fund these 4 CAI plans. They've come through every time we send in the memos, they make sure that they sign it off. They trust that they have in us. It's the one that gives us the energy to do what we do. So to the Deanery, in your absentia, we really appreciate you. We really appreciate you. And then coming to my esteemed judges, coming through there was a short time that we've given you, but nonetheless, you left your busy schedules, you came here, even though we were running behind schedule, but you were so patient with us. You made every time we felt like we were giving up, you always showed us, you got this, go on. For that, we thank you. The way you were adjudicating today, I saw how you are trying to shape this to what South Africa needs. You have planted a seed. Tomorrow, these people will be sitting here knowing that you have left a beautiful food mark. What you have done today, you have multiplied yourself. And what we are about to give you, it's nothing of huge value, but it's a token of appreciation from us. There is nothing that will be fit to give you for the job that you have done. But what we have, we want you to look at it and remember UNISA and remember this audience. We are all saying thank you for your time. Thank you very much.
Thank you, ladies and gentlemen. Thank you, esteemed judges. Thank you to the grander audience. Thank you to our live audience, to the students who walked in after the drama of the knockouts. The 2023 Moot Court competition tryouts and applications will be open very, very soon. Communication and information about this will be posted on the UNISA websites and all outlets of information. So if you envision yourself partaking in this kind of event, please, please, please look out for that information and participate. Throw in your hat and, hey, you know, you could be the queen or king. Just a footnote, the certificates for all the attendants have to be signed at various levels of management. So that's quite an arduous job for today. We'll have that handled and couriered it to your various locations. We have your addresses. So with that, sure.
We thank you so much to our judges. Can my colleagues escort our judges to their room for catering purposes? Seba, and another announcement to the audience. The finalists will be the ones to go out first for the catering, followed by the students in the uniform. And then after the general audience.
All the mutas and then the students.
The participant, the mutas first. Attention please. Can all the regions, the mutas, all regions, go out as the judge go out to the catering stations? And they will be followed by all the students in uniform. And then behind the students with uniform, the whole audience will then follow. Thank you so much. Thank you. You can start celebrating. It's a party after all.